Hi, everybody. This is Doug Dern, drunk driving OWI attorney here in Michigan. Today, I want to talk about sentencing. Now, I don't want to get too much into the details about how sentencing works. Or what it is. You can go online. You can look up, a first offense OWI is $100 to a $500 fine, up to 93 days in jail, 360 hours of community service, 30 days hard driver suspension, and 150 days restricted. Vehicle immobilization, interlock device, and 6 points on your record. High BAC or the super drunk is 180 days in jail, up to 180 days in jail, $200 fine, up to 700, 360 hours community service, driver's license suspension of 1 year, eligible for a restricted after 45 days, if an interlock device is installed, 6 points on your driving record. So those are the two biggies, OWI and high BAC, and then you get into visibly impaired, which is a lesser included offense, and that's still up to 93 days in jail, $300 fine, and it has a restricted license, and it's 4 points on your record. And that's what most prosecutors will offer you on a first offense. Then you get into the harder stuff, like a second offense could be up to a year in jail with a mandatory 5 days. And then a third offense is a 1 to 5 year felony. And then there's other felony enhancements like operating a vehicle while under the influence, causing death or great bodily harm, child endangerment issues, and stuff like that. But there are other things to be considered, like if you have a CDL, you get an OWI, it's an automatic 1 year suspension. If you have a CDL and you're driving a commercial vehicle, then it's a 3 to 4 year suspension. So some of these things are pretty harsh, and I maintain that being a practitioner of drunk driving law for over 20 years, or around 20 years, what I have found is I find that they treat convicted drunk drivers far more harshly than other crimes in the misdemeanor division and the felony division as well. I mean, they're not going to treat a felony drunk driver the same as a murderer or aggravated assault with a deadly weapon, but it's in that category. I mean, if you go on Otis Law and you look at how many people are in prison for OWI, it will astound you. So, first offense, you go in, you plead impaired, you get your restricted license, you pay your fine, you do your year's probation, and it's over, right? I don't agree. Here's why I don't agree with that. Because of the insurance hike you're going to experience could haunt you for a very long time. Now you've got 4 points on your license. You get a second one, you've got a revocation of your license, which means lifetime suspension. The actual law on that reads, here it says, visibly impaired, second offense, a driver's license restoration and denial of 1 year minimum of 5 years if there was that's for a third offense. For a second offense, within 7 years, it is a driver's license revocation, minimum of 1 year. So revocation means lifetime suspension. So if you get a first drunk driving and you don't go balls out to fight it, and you just go in and take the impaired driving, you get a second one, you're in serious trouble. If you go balls out and you fight it and you win, you got to get it dismissed or you get an acquittal,
then you don't have to worry about it. Now, I bring this up because so many drunk driving cases, it's like an assembly line. Plead, 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 plead. You walk into court, you are expected to plead. The courts don't even take into account that 10% of all arrested drunk drivers are innocent. And a lot of times police officers make mistakes. They make illegal arrests, improper stops, improper probable cause. It happens. Folks, these officers are out there in the middle of the night. Somebody's intoxicated, or they think they're intoxicated. There's a joke amongst drunk driving attorneys. Oh, he was operating after midnight. That's why he got stopped. And the police kind of have an attitude, or at least it's been my experience, that if you're driving after midnight, there's a good likely chance that you're under the influence. And that's what they're looking for. So they're hyped up. They want to make an arrest, and they'll do whatever they can. I mean, I've been pulled over after midnight, and I've been treated very rudely, and always the first word out of their mouth, "You been drinking?" And if you had and you said a beer, you're getting a field sobriety test. You've already implanted that thought in their mind. They've got them a drunk driver. So my position is that if you're arrested for drunk driving, if it's a first offense, yeah, you might get off with an impaired. You might get it knocked down to an impaired, pay a fine, and do 6 months to a year probation and serve out your restricted and learn your lesson. But the amount of people that just line up and plead guilty without even taking a shot at it astounds me. You get a super drunk and a prosecutor does not make an offer, there's no reason to plead as charged. Make them prove it. I mean, that's what your attorney is for. Prove it. There are all kinds of defenses to these. I like to start off with the motion to suppress, motions to dismiss. What did the cop do wrong? What did they stop you for? But then the one that always gets me is there's an assumption that you blew a breath test you got pulled over or stopped or you had an accident or whatever at 12 o'clock, and 1:15 you're doing a blood draw or taking a breath test, and there's an assumption that that's what your blood alcohol content was at the time you were driving. And if you think about that, that's impossible. There's no way that a blood test or a data master test that you took an hour and a half after you drove is a reflection of what your blood alcohol level was at the time you were driving. If you ever heard of retrograde extrapolation, you know that you could have alcohol in the stomach. You could have had a few drinks. It's not even in your blood system yet. You get into an accident. You freeze up. Your stomach content gets absorbed into the bloodstream, and boom, you're over the legal limit. What if you were at a 0.07 drinking a beer when you got stopped? There's no way that you were operating while intoxicated when you got stopped, but by the time you got down to the police station, you were 0.08. And a good defense attorney looks at all these things. But the point of this video is sentencing on an OWI case. The jail times, they all carry jail. Some of them carry 1 to 5. Some of them, like if you kill somebody while you're operating, that could carry, what is it? 1 to 5, 1 to 5. Carries prison time, folks. So people think, well, I just got one drunk driving, I'm impaired, but that's going to haunt you the rest of your life. That will haunt you the rest of your life. And if you get another one, you're going to wish you would have fought the first one or the second one. And speaking of the second one, the second offense, drunk driving, unless you get drug court. In drug court, you can get an interlock device and get your license back. But if that's not offered where you're in court, it could be a serious issue. You need to go to trial. You need to fight it. You need to explore every defense possible. Every defense possible. Don't get a lawyer who's going to take you by the hand, go in there, and plead you guilty the first time in court. Okay? This is your life, folks. You need to explore every defense. You need to spend the money. Yeah, I know. It's expensive to fight a drunk driving case, but it's more expensive not to. License sanctions, insurance rate increases. You can never get an OWI expunged. Never. It has habitual implications, both misdemeanor and felonies. Say you take that impaired and you get the slap on the wrist and the year probation and restricted license, and you get another one and you hurt somebody. You're going to prison. It's not something to mess around with. Now, am I saying it's okay to drink and drive? Absolutely not. If you're guilty, well, let me rephrase that. If you're arrested, you have constitutional rights. And those rights include being able to question your witnesses, being able to go to trial, being able to explore motions and options to make sure everything was done properly. And then, if you're convicted, then you need an attorney who is well-versed in sentencing options to keep you out of jail, to do everything they can to keep your license, to minimize your punishment. So when you take that into consideration, a good attorney is going to turn over every stone in an investigation into your case. They're going to go to the actual scene where the arrest took place. They're going to pull the maintenance records off the data master. They're going to verify that the officer that gave you the breath test was certified to do so. They may even bring in an expert witness at trial. It's a rebuttable presumption. The goal or the job of the attorney is to require the state to prove their case beyond a reasonable doubt. There's a lot of gray area in drunk driving that is accepted as fact. We all know machines make mistakes. Those machines have computers in them. You ever set a cell phone by a computer? You ever put a police radio by a computer? What's it do? Even now, with highest technology you have today, lay your cell phone on top of your desktop. You think when you're talking about 0.07 or 0.08 or 0.16 compared to 0.17, that little marginal error might make you a criminal? You need to think about this things, folks. If you've got a drunk driving You need a really good lawyer who is well versed in every defense possible. And if you're convicted, they are well versed in how to handle sentencing. So I would be more than happy to sit down and spend an hour talking to you if you call my office at 810-632-9160. Thank you.